minor disruption. Again, back to regulations. We are progressing through our regulatory list here. It's quite an extensive list, and what I really want to note today is that we are bringing in extra support staff to assist with filing regulations so that we can move through this much quicker than we have been. We're probably the better part of almost 2 years behind on getting things filed, and we really need to get some traction on this. So we're going to bring in a retired annuitant that will help us hopefully get some traction on these regulations. You'll hear later today from Dr. Klingborg. We've got a couple of other things that are being recommended by the MDC that are language changes that would add to this list. So I'm confident that with the additional staffing, we'll be able to move through these much quicker than we have been. There's also a change in the regulatory process that I believe Kurt might have explained to this board at a previous meeting. And I'm not sure how much that will delay the process, but it definitely pushes back the filing of regulations because now they have to go through our agency oversight department and DCA before they're filed with the Office of Administrative Law. That review used to happen after the regulations were filed. So they've kind of changed the steps within which we can get approval from the control agencies before they go to OAL. Are there any questions? Thank you.
Did you had said at the last meeting that you started this process of recruiting a retired annuitant? So
We found one.
you did.
Mm-hmm.
Okay.
Yeah. And actually, this person's been around the department for several years. She used to be the executive officer for the chiropractic board. And since retired, she worked for the medical board, and she's currently a retired annuitant for the occupational therapy board. We're still working out some snags in terms of scheduling, but I think we have someone that's well versed in this and can give us a hand.
Well, I appreciate the whole process that has to go through to get someone to be on staff. But I also appreciate the executive officer's role is taking their time and making sure it's the right person for the job.
Thank you.
And I assume when we go over the budget that'll be, whatever costs for that will be reflected.
Yeah, they're in a blanket, so it's a
Yeah, it's in the group.
Yeah.
Any comments from the public? So moving on to 5B, discuss and consider amendments to the disciplinary guidelines, section 2006 of Title 16 of the California Code of Regulations. And Anne Marie and Mr. Heckler both will outline these changes.
So I'm actually going to call Christy Bell and Candace Rainey to the table so that we can have an update on the memo that's before you. First and foremost, what I want to remind the board is you've adopted the disciplinary guidelines changes at previous meetings. As far as the current changes that are outlined just in this initial cover memo, these are changes that staff is recommending as they go through the probationary process, interviewing new probationers, kind of implementing these changes in terms of our procedures. They've noticed some things that have become less clear than what we once thought they were and have been confusing for our probationers. So this really is an attempt to make sure that when we enforce these standards, these disciplinary guidelines, that the probationers that are subject to these guidelines they understand what's expected of them. We talk about language being in legalese, and they really need to understand what they have to comply with because their license is on the line. So we want to make these as evidently clear as we possibly can. Lee Heller also had submitted some comments and some changes prior to the meeting. And so I distributed a document this morning that has Lee's changes in them as well so we can discuss what she's recommending in addition to what staff is recommending to the board for consideration. So I think at this point I'd like
Anne-Marie, sorry to interrupt, can you tell us which document are the Lee Heller changes?
The one that you have in your hand.
And they're towards the end?
So as we,
One's on the side.
yeah, you'll see the changes on the side as comments. There's also, we'll go through this
Okay,
page by page.
I see.
All these are hers. Okay,
yeah.
got it.
So we will also, though, have Christy kind of outline the memo that's before you in terms of what staff is recommending to change from the last time the board adopted our disciplinary guidelines. So I'm going to turn it over to Christy at this point.
Okay, so we just have a couple that through our experience interviewing probationers that we found some changes we'd like to make. And one of the initial ones is with interview with the board. And basically for consistency, when we had our initial meeting with the Disciplinary Guidelines Committee, we had decided not to list any, I guess, specifics in regards to the non-compliance with each term and condition because it's not really necessary. They're agreeing to it, and it's addressed in a separate term, violation of probation. So in interview with the board, we have a notification that it's going to be considered a violation if they don't appear for the interview. And for consistency, we think that should be removed.
Ms. Bell, I just want to make sure, so this is, you're working off your memo,
Right.
okay? Ms. Heller's thing makes no changes, as I see it, so I just want to, just so everybody can sort of play along.
I thought we'd go through my memo first
do
and
we
then we
just
can address
approve
hers so that
Yeah.
it's not confusing. Okay.
Dr. Waterhouse, are we just gonna approve then as we go through one by one, or?
So I think she's gonna kind of give her report and then we will address them one by one.
Okay.
So she's gonna give her report first.
The next one is tolling of probation. Through all of our interviews with the probationers, we're getting some really great feedback that the interviews are very helpful for them successfully completing their probation. And we've had some instances where someone has become, started their probation, maybe they live out of state, or they're not practicing at that time, so they immediately start in a tolled status, but they do have some requirements that they have to comply with during that time. And we want to make the interview with the board one of those mandatory ones. That way they're clear on what is expected of them while tolled, and then also once they become active probationers. So the only change in that is to add an interview with the board as a requirement while they're in a tolled status. Okay, the next one is submitting to drug testing. It's similar to the original one. We just want to take out the language. You can see the strike through in the example that it shall be considered a violation of probation if they were to have a positive test. And just to be consistent, we want to remove that. They know that they have to comply with testing and that they can't have positive tests. The next one is abstention from controlled substances. And in reviewing this, we noticed that the language, the abuse of dangerous drugs, could be somewhat challenging maybe to prove at hearing. So any use of any drugs or substances has to be with a prescription by their doctor. And we don't want to have to get into the confusion of who defines abuse and what exactly that means. So we want to take it out to be more clear to the probationer.
Christy, I know some of the concerns that have been raised here, things like over-the-counter medications that may show up on drug tests. What is the protocol if we've got a probationer who is taking something like NyQuil or using Listerine or something that shows up as alcohol in the tox screens?
Well, we have more advanced testing than we used to. We do notify them that those things are not allowed while they're on probation.
Okay.
But we do have a blood test called a PEth test that's better able to indicate if there's been large amounts of alcohol consumed in prior weeks. So we do have a way to hone in and make sure that they're not consuming alcohol regularly.
Okay. And if in fact it did pick up something like a NyQuil or something like an over-the-counter medication, how would we deal with that situation?
It's considered a violation. We will notify them that they had a positive test, require explanation, and depending on what happens, it's considered a violation.
Okay, but if the doctor said, okay, I advise this person to take,
We would just need a doctor's note,
gotcha.
and it's considered fine.
Okay, thank you.
Would you mind putting the microphone closer to you, please? Thank you.
Okay, the next one is abstention from alcohol use. prior, it said that they shall abstain from the intake of alcohol. And we want to be a bit more thorough because we have had some instances where people have concerns regarding products that might have alcohol or fermented things, and they're saying that that's the reason why they're having positive alcohol tests. So we want to be more thorough and complete in what constitutes the intake of alcohol. And we took language that has been used by other boards, so it's acceptable, and they've been using it for a while. And we just want to clarify that it's the use of products or beverages containing alcohol, not just alcoholic beverages. This last part, it was raised, I believe, at the July meeting some time ago, that we had only had 3 of the board's options listed in regards to considering a proposed decision. So this was clarifying that language and including all 5 options that are available to the board.
I had a quick, I think, type of question. You have A, B, is number 3, what's crossed out, is that supposed to be C?
It is supposed to be C. It's a typo we can fix.
There's a C there, right
Oh, I see.
before reject.
After non-adopt.
Oh, there it is.
It's hiding.
Mine. Got it.
So are we going back to each of these now? And
Yeah, I think now what we might want to do is, Kurt, did you want to then look at Ms. Heller's suggestions? I know that before we go through each one of these, just perhaps we might want to consider some changes that seem to be necessary. So on page 2 of the document, under tooling and probation, 3rd paragraph in, non-practice is defined as any period the respondent fails to engage in the practice of veterinary medicine in California for a minimum of 24 hours per week. It's not that they have to work an exact 24 hours, but they have to work a minimum.
Page 2.
Where we are on
Page 2, under tooling and probation.
The public have a copy of this document too.
Yeah,
Okay.
are you talking about the Lee Heller document or the one that was in the packet?
no, the Lee Heller document.
Okay.
You can follow along in the one in your packet if you want to make the changes to that one, whatever's easier for you, but it's page 2 regardless of which document, adding in the 3rd paragraph a minimum of 24 hours per week.
And that replaces the 424 hours per week.
Yeah, it doesn't replace it, you just add a minimum of.
Yeah, that's what it's,
Oh, okay. Oh, okay.
Nothing on page 3.
Can I ask questions? As long as we're on this part?
Yeah.
Okay. So, on the 2nd paragraph of tolling, it says, non-practice is defined as any period of time exceeding 30 days, and then it goes on the next sentence. Respondent must comply with the following terms and condition of probation. Or actually, let me go one sentence before that. While told for residing or practicing outside of California, is that referring to the next sentence?
It's not a sentence, yeah, it should be a comma, you're right.
Okay, so while told for residing or practicing outside of California, so these are people that are not practicing in California,
Right,
but they're practicing someplace else.
right,
They're considered to be told in California.
right.
It goes on to say, respondent must comply with the following terms and condition of probation. Obey all laws, quarterly reports, interview with the boards, tolling of probation, maintain a valid license. Does that refer to the license of this other state?
No, it's licensed in California, they have to maintain their California license.
And it's just assumed that they have a license in the state that they're practicing in?
Well, yeah, they wouldn't be able to practice there.
It's not our problem, it's not our jurisdiction.
And they,
Okay.
and they may or may not be practicing.
Yeah, they could be just not practicing. They could just be residing outside of California.
So I think Mark's saying.
Well, it says residing or practicing outside of California. It says while practicing outside of California.
Well, it says while told for residing or practicing outside of California. So they could just be living outside of California.
But if they're practicing, you assume they have a license in that state, and if they're not, it's not a jurisdiction.
Right.
Okay.
Would you recommend maintain a valid California license so that it's more clear?
I was confused by it.
Okay. Okay. Any more changes on page 2?
I have one that should be considered at least. 2 points. One is that if this is someone that is tolling, they are most likely out of state. And would it be reasonable to, when you introduce the idea of interview with the board, could that be done with Skype or Zoom or something so they don't have to fly from, let's say, New York to California? And if
We do
that's,
phone interviews all the time, so
Okay, so
that's
that's
part of,
that's implicit in
Yeah.
there. And then also I'm guessing that the board is implicit too, because you never really define what the board means. Does that mean this board, board staff, what board? And is that a problem or?
Yeah, I believe that it's actually, I believe that that's sort of an inherent delegation on the board staff, because you would never be talking to the board members, you'd be
Right.
talking to board staff.
Okay, thank you.
And I just wanna, Diane's gonna go up, I just wanna add something about the understanding of tolling.
I go to microphone.
Do you want me to go through the microphone, or do you want me to?
You got it? Do you have her okay, or?
Just in terms of tolling, I just want to explain.
It's not for me, it's for the people who watch.
Oh, can they hear me?
no, they can't hear you.
Can't.
So in terms of tolling, I just want to make you or explain something, because you said that usually means they're out of town. That's not necessarily true. It just means that they have stopped working for a period of time. So there could be many reasons for it. Oftentimes it's that they're out of town, but that's not at all the only reason.
Dr. Waterhouse,
Yes.
maybe Diane should be where Lee is so that she has a microphone all the time. And doesn't she sit up here with us when there's space? Oh, okay. And she didn't identify herself when she came to the microphone.
That was the olden days. I used to sit up there with you guys. There was a change.
May I just make a clarification? With regard to the interviews, the preference is that they come in person. We found that that's much more valuable, and there's the exchange of information, the ability to handle questions, provide additional information, all of that is much more effectual when they're actually here. If there are extenuating circumstances and they request it, then we will accommodate them through a telephone interview.
One other change that Dr. Waterhouse noted, first paragraph, the number we left off the 0, it's 30 calendar days. Not 3. Okay, we're gonna move on to page 3.
I'm sorry, but just kind of going back to that point about practicing outside of the state and the comment I made about it not being in our jurisdiction. But if they indeed are practicing with a license in another state, isn't that a crime? And isn't a crime considered to be a violation of probation?
Yes.
Yeah, it would be a violation of probation, but it would have to be something found by that state and then transmitted to the board for it to be actionable. We couldn't say they're practicing unlicensed in another state. That state would have to do something about it, send it to the board, and then that would be actionable.
But a probationary officer would know that they're in another state practicing, wouldn't they?
And through interviews, we might know, but we don't send our.
So would it be that difficult for the probationary officer to confirm that they have a license to practice in that state?
I'm sure they can.
If a person is
I don't know
indeed
that this
doing that,
is this become an issue?
It has not.
Okay.
I guess the determination that they're violating a law needs to be made by the state in which they're
Right.
residing.
Right.
I don't think you want the California board to say you're violating Florida law. Let the Floridians take care of that. If there's a conviction or arrest or some other violation in Florida, then we can reciprocally take action. But as to the determination of whether they're violating the home jurisdiction, we'll leave that up to the home state.
I think we have to.
Judy?
Okay, last thing. So 2 things, I think to Mark's point, it would be nice that if they were on if they're on probation with us, that they're in good standing with, that their license is still going here. But it would be nice to have a copy of their license, it seems like in the probation file for the state and where they're practicing. That's just a comment. And then the second thing is, Jamie brought up Skype or being able to do things like that. I mean, with today's technology, it seems like it would be so much better if we had to do a telephone interview to do it, that you can actually see their face and talk to them. Because as you know, going through your probation talks, mannerisms, the whole thing means so much, right? So I don't know if this is something that we should.
Judy, these aren't meant to be overly prescriptive, so the staff knows how, that's staff function
Oh,
to
okay.
carry out how it happens.
I just would like,
These are
okay, let me just reword. I would like for that to be a part of what our staff has access to from now on, that they do include FaceTime or Skype or Google Hangout or any of those things in their practice. That's all.
Thank you.
Thank you, Judy.
Okay, moving on to page 3. There's no other changes from these documents to what staff had recommended. Page 4. No further changes here. Stop me if you have any questions. Page 5.
Page 4.
Okay. Back to page 4.
Yeah, just, after the cross out.
Yeah.
Does that "and" still stay there? Doesn't sound just right.
Okay, it's out. The "and" in the 3rd paragraph under item 17, submit to drug test, should be stricken, along with shall be considered violation of probation and striking it. Page 5. Kurt, I don't know if you want to speak to Ms. Heller's comment under abstention of controlled substances. She asked what are dangerous drugs and where are they defined?
I think dangerous drugs are well understood. I think that basically means stuff you can't get without a prescription.
Right, and it's under pharmacy law, and I think we know what veterinary.
And it's actually in our Practice Act.
Yeah.
It's BNP 4021 and 4022.
Thank you, 4021 and 4022. Thank you. Okay,
And I would go with item 19, I think Ms. Bell has answered that question.
I do too. The use of products or beverages containing alcohol. Okay, page 6. There was no additional changes. Page 7. I think we need an "and" up under item E. It says reject the proposed decision and decide the case upon the record. Okay. And no other changes there. There's some formatting things that we'll correct when it's not strike out and underlined. Ms. Heller did have some other comments on the disciplinary guidelines document itself. So we can go through that quickly because there's no recommended changes by staff. So if you want to look at Ms. Heller's document, page 1, paragraph 4, insert the word "that" after recommends. So you'll see an underline that says recommends, and it's "that." These are all grammatical in nature. Nothing on page 2. Nothing on page 3. Page 4, 5, 6, get to the next one. Page 8, there was some question as to the use of the term actions. Ms. Heller said she was concerned whether that maybe should be violations. I think actions is the appropriate word here. Prior actions mean actions taken by the board. So it could be a citation and fine, it could be a disciplinary action, it could be something else. So I would argue that actions is the appropriate word here.
I would concur. I would suggest that perhaps actions allows for both the formal disciplinary decision as well as the issuance of a citation and fine.
Right. Okay. So nothing further on page 9, page 10, page 11, page 12. So there was some comment that is somewhat unclear for us that under section 4836.5 and 4837, where it says violation, disciplinary proceedings against veterinarians and registered veterinary technicians. And Ms. Heller's comment is this is not a violation, it's a proceeding. 4837 lists the general categories of violation, so it doesn't make sense to identify maximum and minimum penalties because specific violations are not identified. Oh, sorry. Essentially, Ms. Heller's question was, why are we considering this a violation? And it's not that we're considering it a violation, we're just referring to a section where there is some notion of general categories of violation, and therefore if a registered veterinary technician or a veterinarian were to violate one of those general categories, there is a minimum and maximum penalty. I'm not sure that there's anything else here that requires further modification, but Kurt, I will defer to you.
Your point has something, basically 4836.5 and 4837 talks about, the board, what the actions the board can take, so there is some credence there. My concern is that Ms. Heller's comment, I think, is well taken. I don't know what the board wants to do about it, because like I said, 4836 says the board shall take action. 4837 shall take action against an RVT with notice of hearing, so it's more of a sort of like, here's the authority we have to take action, but our comments are just these sections of regulations, not to be nitpicky, this is statute, so I don't know if the board here wants to go along with this comment, or they want to strike this out. I'm not quite sure what the appropriate action solution is here.
Question? My question is, would it make any difference whatsoever in the disciplinary process, what it's called? Then I suggest we take no action.
Okay. And just leave it as presented?
Yeah.
Okay.
What,
Again, to further clarify my question, can an opportunity be taken by a very clever lawyer to get out of a disciplinary action that should be given with this language?
So when you said very clever attorney, that eliminated me. I'm not quite sure that it can. I do think it may be worth taking another look at this, perhaps, in light of what Ms. Heller said. And that gets me to a greater issue that I'll talk about when the board is concluded. So.
Well, I'll go back to what the purpose of this document is. These are disciplinary guidelines.
Right.
So these are the guidelines that are given when terms of probation are being determined by an administrative law judge or during meetings with the board. And then these are also guidelines that the probation officers have to ensure that the probationer complies. So if by changing any of this language, is it gonna make any effect on either one of those persons or people to do what it is meant to do?
At this point, I'm not sure that it does. There must be, so my theory is there's a reason that the board, even in prior versions, has this in there. The Heller suggestion seems to be that these aren't really, you don't really violate section 4837 per se, it's more like the board's authority to do that. I'm not persuaded this amendment has merit just yet. So my suggestion would be to carry on unabated, and perhaps we can revisit this issue through the process if it becomes apparent that some revision is necessary.
Can we put it as an assignment to legal to get back to the board? Okay.
I just got a text from Lee, and she's just agreeing with everything from her.
Okay, so,
Oh, you can't do it.
there's a little bit of tension here. Ms. Heller is not here, and so, she's not, and this was not noticed in the teleconference meeting. So in this respect, why don't we just continue on as if that comment was not offered? Because it's a comment for a board meeting that was not duly noticed to participate remotely. So let's continue on unfettered, shall we?
So the next change, page 19,
We have some sort of comment.
Nancy, can you approach?
Nancy Ehrlich with Carved. I don't have a copy of Ms. Heller's,
It's on the table.
they're all gone.
Oh,
But this maybe have already been addressed, but the note on page 12 at the bottom, thank you. The unregistered assistant was changed to veterinary controlled substance permit holder. I don't understand that change. Veterinary assistant, veterinary controlled substance permit holder is a subset of veterinary assistants. Not all veterinary assistants hold permits, but they still are not permitted to perform RVT job tasks. So I don't see why you're singling out the permit holders.
yeah, I would agree. I think this should be veterinary assistants and veterinary assistant controlled substance permit holder. I think it should be both.
If you feel you need to have the permit holder,
Yeah.
although they are still veterinary assistants.
But they're separate and apart because they have a permit that actually can be disciplined. I think
Yes.
the reason why the veterinary assistant isn't in here, and Candace, correct me if I'm wrong, they don't hold any license, registration, or
Right.
permit that we can discipline. So this is really for those that hold something that we're removing the vested property interest from. So a veterinary assistant that doesn't hold a permit, we don't have anything to discipline. So I think that's why they were singled out here. If it's a traditional veterinary assistant, there's nothing for us to remove.
Well, but the sentence says the Practice Act is very specific on the authorized duties for RVTs that cannot be performed by, and the Practice Act does not specify duties that cannot be performed by a veterinary assistant permit holder. It talks
And
about.
again, I think the reason why it's singled out the permit holder
I
is
get that.
because we have the license to discipline, the permit to
Right.
discipline.
So are you going to add back veterinary assistants as well, or are you just going to leave it?
I mean, we can for the purposes of clarity, you're
I
right.
think-
It doesn't say, the Practice Act doesn't say that a permit holder can't do things that a veterinary assistant can.
Right.
Again, because of what these are used for, disciplinary guidelines, the veterinary assistant wouldn't even come into play here. There's nothing to discipline. So, I don't know, but thank you for the comment, we'll
Okay.
discuss it.
Thank you.
And Dr. Nunez has a question.
Thank you, Nancy, for finding that. You always seem to find things. Yes, but why is that note even in that section?
That's what I
Because
Kurt just asked, yeah.
So, because all the other boxes have minimum and maximum penalties, but then this has an extra note.
Yeah.
That just says, out of the blue, by the way, the Practice Act has clear definitions of this. And it's
I would
not
agree.
even applicable to the section where it says duty to report animal abuse or cruelty.
So I'm a little bit perplexed about its value here. I'm not quite sure what it adds what it brings to the table or adds to the party. Quite candidly, if we were in the human medicine world and somebody started practicing medicine, we wouldn't be talking about, what the guidelines say, we'd be arresting them. So I'm a little, I don't know what value, it had before, and I'm not persuaded what value it has by this amendment. So, this is on the bottom of page.
No.
Candace or Christy, do you have any comments about striking that note?
I just want to speak to Dr. Nunez's comment. This actually relates to the 4836.5 and 4837, which is the section below the animal cruelty.
Oh.
So it's speaking to the section that regards veterinarians and veterinary technicians. But I agree, I don't know what value it adds.
So we could strike this and it would not then take away from the intent and the use of the guidelines?
Right.
Okay, so for the sake of this discussion, striking the note might be more clear. The next change on page 19, with regard to new ownership, it's item number 7 at the top of the page. This is really for clarification. Respondent shall not have any new, and it should be legal or beneficial interest in any veterinary business. We're not worried about any other business that they may have a financial interest in. Any questions on that? Okay, and then moving on. Page 22, we've already discussed dangerous drugs is defined in the Practice Act, and we've discussed the use of products and beverages containing alcohol and why it was necessary to use that language.
Could we take a look at the second paragraph
Of which page it is?
of that same term number 17, where board or its designee is bracketed? I'm not sure why it's bracketed there if it's not in any.
Page, I'm sorry,
It's page 22,
okay,
paragraph 2.
okay.
Board or its designee is bracketed. I'm not sure where there are brackets there. They're not in the rest of the document.
I don't know. Remove the brackets.
Dr. Waterhouse and members, if you'll indulge me, this is the first comprehensive look I've had at these. Going back to number 16, Ms. Rainey, Ms. Bell, an issue that has arisen, not with this board, but other boards. This is the support group. I'm on page 21, item 16. One of the issues that has popped up is that AAA or NA sort of has a faith-based flavor. And from your administrative flexibility perspective, if a probationer wanted to use some other thing besides without a faith-based element, that would be permissible?
Absolutely.
Okay, thank you.
Moving on, the next change that noted in Ms. Feller's document is page 25. And these are more clarification changes. So under factors to consider when deciding whether or not to hold or not adopt a stipulated settlement or proposed decision, in that first paragraph, before it says, it should, right before consider rejecting, the board may consider rejecting. So we know who's considering or rejecting. And under considering non-adopting, so the next paragraph in bulleted list, changing in item number 1, very last sentence, it says, or other significant unexplained deviations from, and I believe this should be, yeah. Well, I don't know why we say your board's disciplinary guidelines. I think it should just be the board's disciplinary guidelines.
And members, I have to be candid with you, again, going back to my comment. I'm not quite sure what value in all candor, some of this has.
Because it's already.
Yeah.
Yeah, that's the reason it's there.
What Kurt's referring to, and we've talked about this at previous board meetings when we went over the disciplinary guidelines, but this was prior to Kurt's time. This section in the back of the board's disciplinary guidelines explains the administrative process that all boards go through in terms of what their options are for accepting a decision, not adopting a decision, making modifications. These don't have to be in disciplinary guidelines because they really are just administrative procedures. They happen to be in our board's disciplinary guidelines historically. So if we attempt to remove them now, we have to explain to OAL why we're removing each and every section, what the benefit is. So it doesn't hurt to have them in there, but if they're gonna be in there, they need to be right. They need to be, they need to reflect what the APA is.
Mm-hmm.
So to answer your question, they're in there because they've always been in there.
Is that a kind of corollary to we've always done it that way?
Yes,
Okay.
yes.
Yes.
Okay, and I don't think there was anything else. I think that was the last change noted. So Kurt, I didn't know if you wanted to make the request of the board to give you an opportunity to go through these with a fine-tooth comb before we adopt the entire document.
Yes, I'm gonna probably be realizing that your staff has done a Herculean amount of work, this board has done a Herculean amount of work. Probably shut off any possibility that I'll ever get a Christmas card again. I would respectfully suggest that the board may want to consider taking public comment on these, but then perhaps considering deferring this and directing legal staff to review it, perhaps with the proverbial fine-tooth comb. Again, that'll slow down the process a little bit. My understanding is these have not been noticed yet. The language has been approved. To get that far, as Ms. Delanaya has pointed out, we have a new regulatory procedure in place that any regulations go first to the agency and to the department, and then they get noticed. That's a little bit of a change. I do not want to be viewed as an impediment to this process, but I do think there's a couple things that I would like to weigh in on and bring back to the board. So it would be a little bit of a delay. I recognize that, and I certainly apologize in advance, but these sort of happened prior to my arrival on the scene. It's not a denigration of anybody's work that has been done. As your current counsel, I'd just like the opportunity to go through them perhaps just one more time. So I just throw that out on option of the board. The board can certainly say, no, they're good enough and go for it. That's certainly within their realm. So I'm really glad.
Judy, do you have a question?
I just think it's good for Kurt to do that, but I think that so that he's not an impediment, he gives us a time frame. Does he want by Friday, 1 week? Because these have been looked. I've been on the board for 6 years and they've been looked at by so many attorneys over the 6 years. And I'm sure, Kurt might still find something, but I just don't think that we should take much time. I think that he should do it, but we need to be on it and get this done. I mean, we got 2-year backlog on stuff.
Thank you, Judy. And so is there a motion to be made here?
Can I ask one more question before?
Yes, Dr. Nolan.
And I apologize, go back to page 22. And it says in the second paragraph, respondent shall make daily contact as directed by this is where we took out the brackets. Is that, Candace, this was a question for you, is that a routine that they make daily contact with you, or is this after a positive test?
No, this is a routine. We contract with a drug testing company that a lot of the boards use, and that's the way that they determine if they've been selected that day to test. So they either call in or they have the ability, I think they even have an app now, so they can log in on their phone, they can call in. There are a lot of different ways that they can access that information, but that also demonstrates that they're maintaining contact and that they're complying.
And I'm assuming that's a work week, not every Saturday and Sunday, or is that every day they work they have to contact?
No, it's every day,
Every day, including Christmas.
every day.
Thank you.
So Ms. Rainey, if I could be so bold, there's essentially a two-parter. Number one, you're making the contact, and then the day that you're designating the test, you test, right?
Exactly.
Because the condition is check in, and if called, you will serve, correct?
That day.
Members, if I could just clarify, perhaps I wasn't clear. My thought would be to report back to you at the next meeting. That may not be soon enough. So if you believe this package is good enough after having comment from the public, then I would suggest that you go ahead and direct the executive officer to go ahead and prepare this, submit it to agency review, and then for notice, so it would be the commencement of rulemaking. Like I said, I don't want to be in the way. My only concern is sometimes a thorough review by your current counsel. And I know that this thing's probably been reviewed. Make some colonoscopy joke here, but I'm not gonna. Many times, so it really depends on what the board. And I would say that, of course, as we commence, you have the comment period. If there's sufficient comment raised during that period, the board always has the opportunity to go out for 15 days with a proposed amendment. So it's not as if, it's not as if they're not subject to possible revisions down the road.
Dr. Nunez.
I still am a little bit leery about this new process that Kirk told us at the last meeting about how all of our decisions need to go up to the office of the director of the DCA, even though that was removed from our sunset provisions. And I also think that despite his self-deprecation, I think that Kirk is one of the best legal counsels that this board has had. And so I would say that we defer to Kurt to review it and take his time and report back to us at the next board meeting. There's some items that I think need to be rushed through, and there's some that I don't think we have that urgency, and I don't think there's an urgency, unless Candace disagrees, to rush these through the whole process.
We'd like very much to see them take effect as soon as possible, but I don't think waiting until the next meeting is going to make that much of a difference.
Yes, a question.
Kathy, yes.
If we proceed along that route, after the next meeting, presuming we adopt the fine-tooth combed, cleaned rules, then what is then the timeline to actually get them enforced? Just for everybody's,
So regulations typically take a year, from 9 months to a year.
for the guidelines.
For the, well,
These are guidelines.
that are adopted by
that are-
regulation.
right.
But it's important to note that because they're guidelines, the board does have some flexibility with stipulated settlements and what we can negotiate. So when we know there's been clarifying changes to the guidelines that make them more effective in terms of how we're communicating with our probationers. In stipulated settlements, we can write the terms that way. We don't have to wait for these to be adopted to write the terms more clear in settlement agreements. I mean, that again is to the benefit of the probationer. So they don't prevent us from doing some things when it comes to stipulated settlements. Now, proposed decisions, ALJs rely on the guidelines that they have before them, so there's a little less discretion for us to clarify the language. But, I agree that we need to make sure these are in good shape. I also agree that we could continue to make changes to these in perpetuity and never get to an endpoint. So we also need to be careful that we come to terms with it at some point, get them filed so that they're the most current up-to-date guidelines that we have before us to use.
So is it possible to vote on the first 7 pages when it was brought to us originally? Vote on that and then and still have Kurt look at the disciplinary guidelines in more in depth?
Well, we could, but that, we won't be able to file them until you adopt all of the whole document.
Okay, so might as well do it all together.
Yeah.
Dr. Sullivan.
I did speak with Anne Marie, and perhaps we're not in agreement, and I don't want to make sure I put things. There is always a real possibility that I can review these quickly, and then at the chair's discretion, we could convene a teleconference meeting as well. And so I just throw that out there in case there's some concern about waiting the full 90 days until we have the next meeting, because then we would elongate the regulation process by another 90 days. So there is that potentiality to essentially have a quick review, but you cannot delegate me to go ahead and file these or whatever. That's wholly a board decision. So
Dr. Sullivan?
At the last meeting, we did vote and pass the changes in our in our definition or our regulation or definition of petition for reduction of penalty or reinstatement. Since it does take so long to put regulations through, is it appropriate to put that in at this point rather than doing it separately?
So that's a statutory change and not a regulatory change.
Okay.
Yeah. Dr. Nunez?
I motion that we adopt the changes that we just made to this document, and that this document goes to Kurt, our legal counsel, for his quote-unquote quick review. And then if the executive officer notes that there's any substantial changes to what we've decided, then to bring it to the next meeting, but if not, then to go ahead with the public hearing at the next one.
You can't do that.
My concern, that's my motion and it's open to amendments.
I'll second it.
30 seconds. Discussion?
members, here's my concern. If I were to find something that I would have a legal question on, I don't believe, I don't want that. If I find something, it should come back to the board with my findings. That's my concern, because these are pretty substantial.
And I allow for that provision with my motion. I have faith that our executive officer would notice something substantial and bring it back to us.
And bring it back to us in a full conference?
Or at the next meeting.
Or at the next meeting.
So what Mark's motion was to adopt them, if you find any substantive changes that they need to vote on, that they would come back to the board. If not, if there's no substantive changes, I could move forward with noticing these.
Okay, well, this is a case of first impression for me. Respectfully, I would prefer to do it, I would bring it back to the board. But if we consider that if I don't have anything worthwhile, then, but in the event that I do come something, we would convene a 10-day meeting, probably teleconference, and the motion would also be inherent that you would in fact first submit these to the agency and department for their review in the absence of any adverse comments from those two agencies, then have them noticed by OAL. Okay.
Gabby?
Yeah, I think I sort of misunderstood. I thought what the initial motion was and with Kurt's amendments was that if he reviews what we have here and finds nothing substantial, that we could do a teleconference meeting and adopt what we have. And then if there was something substantial, then it would wait till the next board meeting.
If there's nothing substantial, you don't have to get a full vote of the board. If it is
Okay.
substantial, then we could do it by teleconference or we could do it at the next board meeting.
But does Kurt feel more comfortable with the board making the adoption either way?
Yes, in all candor, Ms. Mueller, Kurt would feel that much more better, no matter what I found, no matter if I said this is
That's what I
perfect,
think.
that in fact, we still convene the 10-day thing. We have board members who have the opportunity to say, thank you for that, and then we fully notice it. So that's my greatest level of comfort. The other mechanism proposed by Dr. Nunez is something, first impression to me. I have a little bit concerned because I want to make sure that, in fact, everybody realizes this is the board's product, not necessarily what Kurt thinks is a wonderful idea. And that's That's my concern.
So I
Okay,
think,
Dr. Nunez, why don't you restate your motion?
yeah, I think my motion is clear. I think my motion is bold and progressive. It makes legal counsel uncomfortable, and
And why
I
don't
love
you-
that.
Why don't you
I love that
restate
part
it?
of it. But the motion is to adopt the changes that we have made to these guidelines, then to submit them to Kurt for his quick review. And if there is no substantial changes, as determined by our executive officer, then it will be allowed to move forward to the next process. It does not require that teleconference vote. If there are some substantial changes, then it will move back to the next board meeting.
Judy?
I still second it. I understood it the first time. I think it's a grand plan.
Any other comments? Any public comment? Yes,
Just
if you could come forward, please.
Okay, regarding page 4,
And you
and I
can identify yourself.
sorry, I'm Bonnie Lutz. I just had a couple of comments. I will comment in writing once I have that opportunity. But on page 4, I just noticed suspension from work. That's vague to me. And Kurt, for your education, I'm an attorney that defends veterinarians and actually tries these cases before the ALJs. Suspension from work, I would question. You know, because suspension means one thing, suspension of the license means one thing, but suspension from work is kind of vague. That's on page 4 in the submit in section 17.
You're referring to automatic suspension from work.
Yes,
I'd like to, let you finish, and I'd like to comment on that.
okay. The only other comment I have, and that is because you probably all know, I was just involved in a case like this. If you're going to add this language that says the use of products or beverages containing alcohol, will there be some guidance document or something that will be provided to the person on probation from somebody, either the drug testing company or the board, that will list some of those products, because that information is not widely available?
Is that something we're already providing?
The company we contract with provides it to the probationers as soon as they enroll in their program. They get a list of prohibited substances.
Okay, well, I guess that's the way it's supposed to work, but it doesn't always work that way, because I have clients that haven't gotten lists.
I'll
So,
look into that further.
okay, great, okay. Thank you, that's all I had. Thank you.
Ms. Bell, just to amplify on that last point, when somebody signs up with drug testing, somebody signs up with a contractor, they give them a list of, hey, don't use this stuff because it contains macaroni or whatever. Did I hear that correctly?
A list of
Oh.
prohibited
You
substances.
just
Yes.
use macaroni because to throw you off. So anything that would potentially, let's make it, anything that would potentially contain alcohol that's not necessarily an alcoholic beverage. So they do give you lists of things like Listerine and NyQuil and
As hand sanitizers, supplements.
sanitizers.
They give some examples of things that you might not realize have it in it, but it is possible it could contain it.
Thank you. And then, as to the first point raised, this is sort of an issue for me, because if you recall, the board, the department, and the legislature passed what was called the uniform standards for substance abusing licensees. And the language that was just discussed is that there's a slight nuance, and it would say you would issue what's called a cease practice order. So, the cease practice means, obviously, don't practice. Thank you, Captain Obvious. But it's not a suspension, because suspension has a certain flavor within the Administrative Procedure Act and with due process, that if you're suspending something, you get a notice and an opportunity to be heard. This is somewhat lesser than that, in that you would say you tested positive without essentially a good reason, let's say, and so that we are issuing a cease practice order. And so I'm a little bit, because the board hasn't gone to uniform standards yet, correct?
Right.
Right.
And so we're kind of, this is sort of an unusual circumstance here because, like I said, this was, as Ms. Delanaya pointed out, this is what it was before. This is one of the things candidly that I would have caught because in my world, in Ms. Liz's world, I think would have been a cease practice order and not a suspension from work order. So that was one of the things that I was gonna catch, but now it's caught.
Okay, do you call for a vote?
Any more public comment before I call for the vote?
Any other public comment, and then we'll call for the vote? Anne Marie, call roll.
Okay. Dr. Waterhouse,
Yes.
Dr. Sullivan,
Yes.
Dr. Nunez,
Well, it's my motion. Yes.
Dr. Nolan,
Yes.
Jennifer Laredo,
Yes.
Kathy Bowler,
Yes for that bold motion.
Miller, and Judy Mancuso.
Yes.
Thank you. Motion carries, and Kurt will report back on his changes.
The next is the MDC report.
Anne Marie, did you want to talk about
Um,
4053.6?
We're asking for a small break first, so we will have a small recess and start.
Thank you. Thanks for welcoming me back. And I'd like to report on the very effective meeting we had yesterday with the MDC. You should have a document in front of you, kind of a summary of yesterday's meeting. Thank you to Nina for getting that printed for me this morning. I appreciate that. The line items, you will see that it starts with number 4, and those correspond to our agenda items. And so you're not missing 1 through 3. They were things like our minutes and introductions. I did notice, however, that as this got converted from a Mac document to a Word document, that we got to items 9 and 10, it did misnumber those, 9, 10, and 11. So you'll see on the 4th page, we've got items 6 and 7, on the 5th page, item 8, and those are items 9, 10, and 11. Again, as it corresponds to our agenda, and that's just more of how Microsoft tries to stick it to Apple, but that's a different story. So item number 4 was an update from the Complaint Process Audit Committee. That's Drs. Pollard and Dr. Grant that are on that. They did attend an expert witness roundtable in San Diego in November, and so they discussed that particular roundtable. And one of the things that Dr. Pollard did discuss was the concept of having 2 expert witnesses look at each case. And so that's something that comes up from time to time, and other boards do have that. But as he's kind of drilled down on this and has been looking at the complaint process pretty closely now for a year and a half or so, really his conclusion is that that wouldn't improve the outcome of the product, that we do have an expert basically on each side, if you will, when there is an issue, and that too many cooks don't necessarily improve the product in the kitchen. So again, just as we are pondering different ways of doing this, it felt that that maybe wasn't the direction that would be ideal to go in. That was not a big conversation point, but I thought it was worth bringing that forward to you to know that that was brought up. And I would invite you to actually see what he said in the tape, because he certainly said that better than I could have. So a very compelling statement. The conclusion is certainly that the complaint process audit subcommittee feels that the product, the complaint process itself, the consistency, the clarity, et cetera, continues to improve. And really the feeling is that ongoing training of the expert witnesses, and then of course training new expert witnesses, is worthy and should continue. So that was what I got, what we got out of the complaint process audit subcommittee. Will be ongoing. The second item was labeled discussions and consideration of extended duties for registered veterinary technicians. And As background, this line item at our last meeting, at the MDC's last meeting, really was about shelters and RVT extended duties within the shelter. And that kind of gets melded into another agenda item a little bit later. But what happened was we did have a submission from CARVTA right before the last meeting. And in that submission, there were a number of items there that CARVTA suggested essentially veterinary assistants be excluded from being able to provide those. And so it's really more of an exclusions for veterinary assistants in private facilities language. And you had a list of 7 or 11 items. It got pared down to 7, and those are the 7 that are printed on this paper. However, the MDC is not ready to tackle this yet. The reality is that we need further guidance from the Veterinary Medical Board. And the deal here is a discomfort that when anybody brings forward something and says that we need to change X or exclude X or expand the scope of practice, what burden of proof, evidence, et cetera, should be provided to go along with that? I mean, I have this idea, we should do this. Okay, well, that's great, but there probably needs to be a little bit more than a we should do this when these ideas come up. As you know, we have limited times in these meetings to do some of this work, and if somebody thinks that something is a good idea, great, then give us a little bit more. And as we talked about it, we kind of felt that we need to take a step back and sort of create a process, a metric, some sort of scale or pathway or whatever you want to call it, when issues like this come up, that we can run this through a checklist, a series of guidelines, a tool. And we certainly were discussing or using 3 key words when looking at this list and just kind of pondering what that tool might look like. And we were talking about using words like access, need, and harm. And so those were the 3 that we captured as we were trying to sort out when any well-meaning group brings a list or an individual brings something in front of us, and again, with a conversation about scope of practice, what is that tool? We don't have it at the MDC, but we do feel that that should be something that can stand the test of time, because we've also seen where something may be allowable when you have one group of 5 people, and when you get another group of 5 people, it's not. And yet those same 5 people are serving on the same type of a board. Well, that's not a consistent product. That creates confusion, and it's not helpful to the consumer. It's not helpful to the regulatory agency. So the MDC recommended, this is the red writing there, that the Veterinary Medical Board form a working group to discuss duties beyond that included in the existing list of RVT tasks that should be excluded to RVTs only. And we felt that working group should consist of members from CVMA, CARVTA, RVT school personnel, veterinary assistants from various practice settings, with a liaison from the MDC and the board respectively. And that is our proposal.
Okay, do we want to tackle these one at a time, or do we want to get the whole report in? Okay. Discussion. Yes, Dr. Nunez.
So in response to your question on what direction from the board, I would like to refer back to, and Kirk will be very proud of me, that consumer protection is paramount. And so when considering these list of duties, and the point was made yesterday whether or not this should be added to the list of RVT duties or excluded from the list of unregistered veterinary assistants. There was also a discussion that talked about determining what harm has been done, and I think that is very important. I think that's probably a reasonable starting point, and that would involve going back to perhaps Candace with complaints received or actual harm that has been done to determine have these duties performed by veterinary assistants resulted in harm and therefore deserve to be put into a restricted class.
If I may just interject, I mean, I think that we, of course, want to be retrospective, and that would be where your complaint data would come in. But we also need to be prospective. So let's say, for example, that LASIK eye surgery for dogs became available. Well, it's technically not using a scalpel. It certainly has the name surgery involved with it. But would we then, as a board, choose to regulate that or not, and in what way? And so here's this new modality that we've never considered. How would we handle that, and what cubby do we put that in? Is that DVM only? Is that RVT, and so on? And so again, that's where we're needing some help.
And it's good to be prospective, but also you have to at some point rely on the discretion of the veterinarian delegating these tasks.
Dr. Sullivan? Oh, sorry, Judy.
So there was 11 items that were exclusions to what veterinary technicians should do, and that only RVT should do.
That veterinary assistants could do, yes.
Assistants, sorry,
Mhm.
assistants.
Mhm.
It seems to me that the MDC and the RVTs could debate this and come up with something, or that the professional folks here on the board, it seems like one or the other. I don't know that we need to make a subcommittee. It seems like, I'm just saying maybe going with this approach in red is becoming more bureaucratic, and that we already have the people in place that should be able to make this decision. And to your point, I think that, multiple RVTs have to be involved in the decision, multiple veterinarians. But I mean, we have that on 2 existing boards, and I don't see why we need a subcommittee. To me, it seems creating, like I said, more bureaucracy. That's all.
Thank you, Judy. Dr. Sullivan?
Yeah, I think the request, if I'm not mistaken, is a committee of stakeholders to set up guidelines to address these issues. So that, right now we're looking at 7, next meeting we may be looking at another 3, next meeting another 5. So the task force is to set up guidelines that are kind of the screening mechanism, so that we're not having to address every single item that comes down the track. It's looking at criteria that have to be satisfied before we do the work of going after or writing regulations.
So in regards to this, I know this is a consumer protection board. My focus is focusing on protecting the patient, and just using the example of the rodeo, just because it's not being reported that these things are being done does not mean that harm is not being done. So these are skilled tasks, and I know this is an area that could demonstrate risk, so I don't see why we can't be proactive in researching this. So I definitely agree that we need to have a task force. There might be more than what's on this list, there might be less, but it needs to be looked at. I'm not the expert, nobody here is. We need a bigger group to look at this to make the right decision.
Dr. Nolan?
I'd like to go back, I think, to what I think I heard John say, which is I think what Dick just said back to you, but which is not really reflected per se in the wording in this red paragraph. And that is, you would like us to take a step back and actually form a template for examining these sorts of things. And I agree with that 100%. I think that we can get down in the weeds really quick. I think we do need to get in the weeds, but I think we need guidelines when we get down into the weeds. But again, I don't see that in this paragraph that you provided us. So I'd just like you to clarify, you are indeed asking us to come up with a template, a guideline on how we look at these individual requests.
That is correct. We're looking for a tool or a set of guidelines that would allow us then, any group, to run that through, and perhaps again it's meeting a certain level or burden of proof, et cetera. Proof of harm, other than to say something's just inherently harmful, is maybe does not have enough teeth in it. We need a little bit more than that to understand that, and it would be helpful if certain groups, when they wanted to put forth issues like this, if they did some of that work other than just say, we think this is dangerous. And so we need a tool so that they know, okay, here are the things that we need to do as we move forward with this to show that there needs to be a change.
Jennifer?
And just to clarify a little bit, it was mentioned at the meeting yesterday that potentially people could come to every single meeting with suggestions. So that's why they were asking for some criteria, groups of procedures versus specific, to create a guideline so that it's not every single meeting suggesting revisiting these and recreating them.
Yeah, and I, excuse me, I understand, excuse me, the concern and the need to review this, and it must change all the time as equipment's changing and specific procedures are changing. I wonder, I kind of guess I like the idea of the task force, but I also would love to see some data about what in the complaint process is probably the best place we would see that, where there have been issues, and obviously you hold the vet responsible, but where if we've seen a lot of issues in certain cases with different kinds of equipment, and I'm wondering, or procedures, and I'm wondering, is this opening a box that we're going to be constantly adding to? I've been on the board a couple of years. I don't know if this has happened overall over time as advances have changed and been made in the last 10, 20 years.
So in my experience, when there's expansions of scope of practice that are kind of emerging, so we're talking about emerging things, that isn't the board's role. And we keep going back to this. What in this list is really something that we need to react to because we're placing, and consumers, Jennifer, are the patients and the clients. So that we don't distinguish, they're not separate and apart from one another. So are there things that the board has an obligation to respond to because we're placing the animal at risk? And that, I think, is where we're looking for those guidelines. How do we know this currently exists as a risk to the patient? And the red, I'll take responsibility for this red language. What it is the recommendation was we need to form a task force to find out where are there risks right now. Are they in certain settings? Are they, as I mentioned yesterday, is this a delegation issue? Is this a supervision issue? Is this a lack of competency issue? And that's what we need to look at. But again, just because they're emerging items that an RVT could do or a veterinary assistant could do doesn't mean that the board has an obligation to further expand their scope of practice. In fact, I would say that's probably counter to what our role is as a consumer protection board. We're not here to expand anybody's role. We're here to respond to a threat or a risk that we know is real. And it doesn't mean that we're constantly reactive, because I can tell you, just based on what I know about the complaints and the disciplinary proceedings we see, it's not just about this. I mean, I think there are some things in here that probably have happened. But I mentioned yesterday, we see veterinary assistants do surgery. Whether or not that it's already a violation of law, they're not supposed to do that. Those things aren't going to stop happening because we write new things into the regulations. There's a certain percentage of the population, unfortunately, that's going to break the law. So we need to figure out how real this is in the professional community. And bringing together this task force can talk about their own individual practice settings and what their delegation of tasks really are. And then we have a better perspective from people that are in the workforce, who's doing this, and under what level of supervision, and what personnel is really assigned to these tasks. And that's how we'll have a better understanding of how much we need to intervene at this point in time.
So, and I think I can speak for the veterinarians here that I would like to hear information at this task force about what's going on in specialty practice and what's going on in emergency clinics, because I don't know who's doing exactly what here. So I would like to see a task force as well. Dr. Sullivan.
I have a technical question. Is this, if, at least in the way I've formulated motion, would this task force be formed by Cheryl or John? Is it coming from the board or from the MDC?
It's really kind of the board's oyster here. You can allow your motion you can allow to be populated or constituted as you see here, the people coming in and off. It's really whatever the board wants to do. You could delegate it back to VMB for them to create, or the MDC. Sorry, I had a DLT. Thank you for the opportunity, Dr. Sullivan. So it's really kind of your oyster as what you want to make of the motion. I think this is wholly before the board. Just two things from a legal perspective. Number one, with presuming we're going to have more than 2 members here because we have various commas in here, so this is going to be a duly noticed endeavor. So we'll have opportunity to comment and everything, agendized and everything else. The second thing is, as your attorney, I just want to make sure that we understand the nomenclature. Under the government code, whenever we say guideline, we can certainly have guidelines. However, no guideline is enforceable unless it's been adopted by the agency as a regulation. So I just want to make sure that in our disciplinary guidelines that we tackled ad nauseum just a moment ago, those are ultimately incorporated by regulation. So if the board wants to come up with a guideline, they're perfectly authorized to do so, but there is no enforcement of that guideline unless adopted by regulation. So
I think for clarity, we're not talking about guidelines in terms of the tasks, we're talking about guidelines in terms of how to assess whether or not we're dealing with something that poses a risk to the public. So those are the guidelines, is what criteria do we use to assess risk?
Dr. Sullivan. Dr. Nolan. You guys.
So I'm assuming that we are looking at this to assess whether our current regulations are not protecting the public. Because currently we have regulations that protect the public from these tasks being done inappropriately. Because it's the veterinarian that's ultimately responsible.
Dr. Sullivan.
I move that our president form a task force to respond to the MDC's request of a working group to discuss methods of evaluating procedures that are proposed as to their qualifications to develop regulations. I hope that's vague enough.
Jennifer seconds. Any other discussion? Dr. Nunez?
Would you consider calling it a working group? Task force can get complicated.
Working group.
I don't care what the president calls it.
I like working group.
Have a beginning and an end, or is it ongoing forever?
It would have a definition of developing these, and I'm going to use the word guidelines because I think that's what they are. And, it's a very narrow scope. It's not looking at these 7 issues.
Its scope of practice?
No.
What is
The
it
scope
exactly?
of the committee would be very narrow in addressing what is necessary, what criteria is necessary to bring to the board or to the MDC, actually to the board first, to request regulations concerning that task.
Oh, that's good. Okay, I got it. Thank you.
I liked your wording, methods of evaluating. In other words, it's a template, it's a guideline, and you stumble on the word guideline, but this is what you need to bring to us so we can effectively and efficiently look at whatever task or procedures come up that is questionable.
Process and procedures.
Any comments from the public? Yes, please come forward.
Yes, Bonnie Lutz again. I just have one comment, and it seems to me, just listening, that what you're talking about, and I think Anne Marie referred to that, is you're talking about a standard of care determination, which really isn't appropriate for the board or to have in guidelines. I mean, it's one thing to have a regulation that says RVTs can do these things and veterinary assistants cannot do those things. But when you start specifying standards of care, that's beyond your scope, and it's also something that's a moving target. I mean, you'd
I
be
don't know
doing
that-
it forever.
I don't know that we're really determining standards of care, we're trying to determine a process for when people bring things to the board, how do we determine if it should be in a list?
Well, and that's
That's-
appropriate. I'm just saying that
Yes.
as far as a guideline that looks at, like standards of care or scope of practice is not really something, it's more of a standard of care issue. Whereas, right, as long as you had a way of approaching different complaints, that's a different thing that you're looking at, basically. Because it sounded to me that what you were all talking about at first was, what are the standards of care? And as you know, I mean, that continuously changes. So you'd be chasing that forever.
We're looking
And
at
it would be
methodology to
impossible.
how to approach whether or not it's appropriate for the board to take on a regulation. So what methodology do we use to assess whether that's an appropriate place for us to engage?
Thank you.
Any other comments from the public?
Thank you, Madam President, members. Members, I am a little bit troubled by this, and here's why. First of all, the direction this is going is not consistent with the red paragraph. Because the red paragraph indicates that there's going to be a specific list of tasks examined to see who can do them, essentially, if you will. The second thing is, I'm not aware of this board having the authority to say, here's what happens, here's what somebody has to meet, some threshold that somebody has to meet to bring a request for regulation change to the board, because the government code provides what we call a direct petition or direct access. You can actually write to any agency that promulgates regulations and say, I had a wild idea while doing X, please change, revise, or adopt a regulation to do that. And the mechanism is the agency then considers that petition, and whether they can adopt it, they can deny it, or whatever. But there is no minimum bar. You just write a letter saying, please adopt, or please amend this regulation. So I'm a little bit troubled by some sort of, chasm or bar or something like that you have to say a person of interest party must meet this threshold before we'll consider the regulation. From a legal perspective, I'm a little bit troubled by that. The second thing is, the third thing or whatever, I was never very good at math. The other issue is, I think the determination really is, let's be candid, there's technology out there that's running the 100-yard dash like Usain Bolt. And then there's government who's trailing behind at the speed of about a glacier. And so there's always going to be understanding that the private practice, private world, whatever, will get out in front. My tenure with the Medical Board of California, doctors were always HMOs, insurance companies were always writing in, hey, can a medical assistant do this? Can a PA do that? And we would have to say, these are the regulations that will authorize what a medical assistant or a physician assistant or some other physician extender can do. And then they would write back and say, thank you very much, and then they would go ahead and do it anyway, or whatever action. So I just want to be clear on this, that there is going to be an opportunity. No list will be exhaustive, no list won't be obsolete, because Silicon Valley is 90 miles from here and they have a way of innovation. I just want to make sure that the members know what they're doing. Number one, a little concerned about the issue of the bar to get over for us to consider something. Number two, the concept that no list will be exhaustive, it'll be obsolete the second we adopt it. So, thanks.
Kathy?
I wasn't actually thinking that this little working group was going to be to create a criteria about whether to take something on or not. I thought it was more about to review the request that is being before us by MDC, I guess from CARTA originally, about whether there is a need to do some additional restrictions of duties to RVTs only that are happening in vet offices now, and that this working group was going to try and ascertain whether that's an issue and a problem, and what we need to do to make changes if necessary to our act and et cetera, to either exclude certain activities unless you are an RVT, or to let things go as they're going now. I mean, I thought it was a more of an informational thing to look at the whole situation to see what the problems are. And if there are significant problems with certain issues and certain procedures, then tackle those, but not coming up with a final list.
So Kurt, when people write into the DCA, whichever branch, and want, suggest a certain thing, so then one person decides?
No.
So it's gotta be a group, so this
Right,
is,
the
we're trying to
group-
find a working group to.
The group would be these kind of folks sitting right here, so if I were not in this seat, but I were an ordinary citizen, and I wrote to the veterinary medical board and said, I want you to adopt a regulation, I'm using hyperbole now, that all veterinarians must be left-handed. Please adopt that regulation. We would write, I would, as your attorney, I would write back and say, thank you for your petition. We will consider this at the next regularly scheduled board meeting. That issue would come before the proponent of the thing, would probably send it back to Clean Board of the City. We would present it, and then the board would go. Whatever the board would go. That's how that process works now. I'm just saying, since that is unfettered, I'm a little bit concerned about us putting another, some sort of like a specific thing to this group. That's my concern.
I was originally gonna say, this is why I disagree with legal counsel, but I'm gonna say, this is how I would assuage legal counsel's concerns. The motion that was made is not referring to any list.
Yeah.
The motion that was made is referring to a process that would evaluate these tasks or duties. And the other point that you made was your concern of whether or not we have the authority to establish a certain bar, or as Bonnie Lutz put it out, as to establish standards of care. We kind of already did that with the original list of restricted duties that is already in our Practice Act, because we feel that these duties have such a potential to cause harm that they need to be performed by somebody who is well qualified to do so. And again, we're not adding a list of new tasks, we're creating a mechanisms to evaluate this, because as you pointed out, technology is always going to be ahead of government regulatory bodies. But if we have, I think it's another bold and progressive motion, because it establishes a mechanism for us to address this before somebody else addresses this and tells us what tasks can and can't be done. I'd rather it come from this body than from another source.
Judy?
Okay, I think this is to Kurt's point. I work on legislation, right? I go to senators and assembly members and say, hey, there's a pet overpopulation problem, and we should do this, right? And they say, well, where's your documentation on that? And so I provide all the statistics and experts and whatnot, and then they decide whether to carry a bill to make the change to law to do something that I've brought to them, right? So to Kurt's point, we can't impede that. We all have the right to petition our government, and that's what I'm hearing. Now, on the flip side of that, what Kathy suggested seemed like what we should be doing, that we have a list before us that we have to evaluate. And to me, this list can be evaluated by our board or by the MDC. I don't understand why there needs to be extra people, because we have our expert whiz-bang RVT representative on the board. We've got all you vets and us public members to make the decision on this. Or we have the MDC who are qualified professionals. And I think that layer in between is what Kurt said is, and I'm just gonna call it another layer of bureaucracy, which I don't think should exist, because people have to be able to come to us and ask for changes on things.
Okay, Dr. Sullivan.
Yeah, I don't think we're impeding anybody from bringing even this list of 7 items forward. What we, I think, are doing is developing some metrics to decide the value of each of those.
That's different than coming up with a template on how to come to us and bring us things. Those are two different things.
It's criteria to determine, I would say, for the board or probably the MDC to use to evaluate the value of that request. We're not impeding any request from coming in.
But you're adding
We have to
bureaucracy.
have some criteria to evaluate all on somewhat of the same level.
Okay, so, we ready to vote? Do we call for a vote?
I think
I do have one more comment.
Yes, Dr. Nolan.
I went back to access, need, and harm that John brought up. And I think that really stirred in me this whole desire to have a metric system, not necessarily that someone from the public has to bring us that information, but it's an internal checklist that we can start using to evaluate. So that's kind of how I was looking at it, Kurt. Not so much, oh, you have to bring us these things for us to consider what's going on, but more an internal, we need to really have an understanding and grasp what the access, the need, and the harm issues are or are not.
Jennifer.
I will be happy if it is looked at and evaluated any way we do it, but just wanted to make the statement. I don't know if anybody has ever worked in specialty, but I have, and there is the potential risk for harm with a lot of the tasks that are being done by assistants, by anybody else, and it does need to be evaluated in any way, shape, or form that we evaluate it.
Okay, we ready to vote? Call for a vote?
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller? Judy Mancuso?
No.
Motion carries.
We good? You want to keep going for a little bit?
Keep going.
Okay. Our next agenda item number 6 was the discussion and consideration of proposed amendments to RVT job tasks, emergency care. And on that next page, on the second page of the document, you have 2069 emergency animal care rendered by registered veterinary technicians. And we've added an item 9 there, which reads, administration of a drug or drugs in compliance with state and federal laws to manage the pain or to sedate an animal for examination or to prevent further injury. Such a task shall only be performed after direct communication with a veterinarian licensed or otherwise authorized to practice in this state. In the event that direct communication cannot be established, the registered veterinary technician may administer the drug or drugs in accordance with written instructions as established by his or her employing veterinarian, or in the case of a sanctioned rodeo or other sporting event, the veterinarian charged with the responsibility to provide treatment to the animals at the rodeo or event. So this language was in response to communication that came out of the Sunset Review hearing, and while it has some it does influence how animals may be treated for managed in terms of pain or sedation in the rodeo setting. It's not exclusive to the rodeo setting. So it allows RVTs in other settings with, as you can read, direct communication with the veterinarian to provide some potentially necessary pain relief or sedation.
Dr. Sullivan.
I have a little bit of a concern. Have we adequately agendized this item to vote on today?
It's kind of a close call, Dr. Sullivan, whereas it was mentioned on MDC's thing as a possible regulatory revision. We do have number 10 here, 10A, the agenda that, so theoretically, yes, the board could in fact move to commence, in my opinion, could move to commence rulemaking if they so wish. This would be the same thing. Not like item 5B, but this would be an initial commencement of rulemaking. I want to point out, it was asked to me prior that the NBC presents their recommendations to this board. This board can say, thank you very much. We direct staff to research this issue further, prepare a more comprehensive analysis, do whatever before it makes a decision. I would suggest that this is somewhat unusual in the rulemaking, is that most of the rulemaking things are accompanied here by a memo, Mr. Bell's memo, when we talked about guidelines. We have no real analysis here prior to commencing, so the board may want to consider having that sort of analysis, memorandum, fully explanation provided before it commences rulemaking.
Any discussion? Dr. Sullivan?
I'm very comfortable with this, but I'm also on the MDC, which kind of gives me a skewed view of things. So I've gotten a little nervous over the last couple of meetings that some of these items we may be rushing through without maybe proper public input or proper background for other board members. So that's what I'm bringing up.
I have a question about another sporting event.
I have no clarity for you. I mean, it just, the idea was, again, we understand the California Horse Racing Board has their own,
Yes.
it's their own entity, so we're not trying to influence that, but
Dr. Nunez?
Well, I think that was going to the Mexican videos.
Sure.
yeah.
Yeah. Or the sporting event could be.
But haven't we, and I'm comfortable with this language as well, so, we've made motions to direct staff to, create language for proposed regulation. Can I make that motion?
That'd be good for. Is that with that?
Given Dr. Nunez's relatively recent history of bold motions, I would just respectfully ask, I didn't quite hear what you said.
Oh, I made the motion to direct staff to establish language for proposed regulation.
And as part of that would go through you too?
So mea culpa, this language is mine.
Yes, okay.
This language is mine. What I'm suggesting is that usually with the rulemaking process, when it gets to the board level, there's sort of a memo, if you will. We have, if you look on your thing, when we talk about number 14, item 14, we have this memo talking about fees, stuff like that. What I'm suggesting is some of the analysis, frankly, isn't here. Pulled up from NBC. This was my attempt to address the problem, and so I'm just saying that the board before it notices this for rulemaking may want a more comprehensive analysis from me or the staff members. You know, what could this do to the profession? What are the benefits? What are the risks? Sort of stuff. Just saying that perhaps that's not here yet. The board can do what they want. But it may be prudent to pump the brakes here just for a moment, just to the next meeting, get that kind of analysis, and then move forward.
Dr. Sullivan?
And in addition to that, I think we may need to hear from the public too. Agendize it for the public's concern too.
So just so we're clear, when you notice regulations, it goes out for a 45-day public comment period, so it doesn't preclude the public from participating. I think where we're in a unique situation, all due respect to council, is that the MDC is the fact-finding body for the board. And the MDC, that's why it's agendized this way, where that discussion and that rationale happens at the MDC. The MDC's role is to make recommendations to the board. If the way this board would prefer to see these recommendations is Dr. Klingberg provides his report, and then at the next meeting, we agendize all of the language for further discussion at the Veterinary Medical Board. We can do that. I will tell you that when I came aboard here, one of the concerns that was raised to me is that we're having these multiple discussions. So the MDC is doing all this vetting, and then it's being re-vetted at the Veterinary Medical Board level, when the whole intent of the MDC was to have those very healthy, kind of robust discussions about why we're doing this. So they're noticed, they're televised, the way the agenda reads, it provides an opportunity for the Veterinary Medical Board to take action on the recommendations if they so choose. Now, if there's any concerns about the way the language is presented or the reason, the rationale behind the language, the board can say, I'd like this brought back for further discussion at the next board meeting. But again, what I heard early on in this process was that the MDC was doing all this work and then it was being basically redeveloped at the Veterinary Medical Board level. So in an effort to try to reduce that duplicative discussion, we were looking at this as a recommendation for the board to do one of two things: adopt the language and move forward, or say, no, we're not comfortable with this, we want to agendize it for a board meeting. That's what I see your options are.
Dr. Nunez.
So I'm waiting for a second for my bold
Well, wait,
motion.
I forgot your motion. Are we, wait a minute, can I ask a question? Are we we're just voting on this red?
Yeah.
We're voting to adopt this.
Well, to direct staff to propose language for regulation.
But this is the proposed
No,
language.
this is,
Yeah.
the motion would be to adopt this red language.
Yeah.
And I'll make that motion.
I already did.
You did not, you did something else. All right, I'll second.
Judy's.
Okay, I think I.
Yes, Dr. Nolan.
I think it needs a period.
Yeah, it does.
There's a period missing.
Or, yeah, I just wanted to make that.
Any other discussion?
So again,
Dr. Klingberg.
I'd just like to say that if the MDC is bringing things to you that are controversial, it's my job to alert you of that is happening. And you'll recall at the last meeting where the MDC voted in one direction on student exemption, and yet we spent some time talking about the counter argument there. Yesterday, there was no negative comment from the public on this language, and in fact, positive comment from Eric Mills, who's championed the rodeo issue as well. So we felt that this language passed all the muster that we could have asked for it to pass.
So Kathy second, so we're gonna vote.
Did council have another comment?
since I'm doing so well, just want to say that inherent in the motion would be to prepare the necessary rulemaking documents. This would be the notice, the initial statement of reasons, any fiscal statements, and then submit them to the department and the agency, and without any in the absence of adverse comments, proceed with the rulemaking process. I'm sure that's just inherent in the motion.
That sounds great, thank you.
Any comments from the public? Call for a vote?
Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Dr. Nunez.
Yes.
Dr. Nolan.
Yes.
Jennifer Laredo.
Yes.
Kathy Bowler.
Yes.
Lee Heller. And Judy Mancuso.
Yes.
The second item within this agenda, also in red on the next page, members of the MDC also expressed interest in statutory changes to either Penal Code Section 597.1 or BPC 4840 to authorize RVTs to transport controlled substances for the purposes of administering drugs in emergency situations. I'm remiss that I did not print out for you that particular paragraph in Penal Code 597.1, which, if you have your Practice Act, is at the top of page 311, and it's the first paragraph there. Basically, animal control officers do have the ability to administer a tranquilizer with direct or indirect supervision, as determined by a licensed veterinarian, to gain control of an animal and that would be to protect the health and safety of a wild, stray, or abandoned animal or the health and safety of others. And so it kept coming up yesterday that why do animal control officers have this ability and yet RVTs do not? So what we would ask is that examining this, exploring 597.1 BPC 4840 would become potentially one of the priorities for the MDC.
I move to adopt it.
I second.
Any discussion? Dr. Sullivan?
To clarify, this is for the MDC to investigate this?
That's right, would explore this issue as it relates to RVTs and having some of the same rights and or authority as we see with animal control officers.
Well, I'm on the MDC and I will voice my opinion on that at the MDC because I am not in favor of this.
Any other comment? Jennifer?
Just a comment, not to disagree with the Vice President, but I am in favor of it. The point that was made yesterday by Dr. Juicy's, which was a very good point, is that an animal control officer, maybe hypothetically somebody I trained on how to hit a vein, is authorized to take a controlled substance into the field, but I'm not. And I would say that I'm more skilled. So I would say in the best interest of protecting these animals that are in need in the field, I would like the RVTs to be able to use a controlled substance that would be better for the health of the animal than a substance that is not as useful.
Any other comment? Any comment from the public? Dr. Black, want to call for a vote? Oh, sorry.
Alen Moon Carvta, also as shelter RVT, I have to heartily agree with Ms. Laredo here that this is vital that the RVTs in shelter not be put behind the animal control officers where they're going to use a dart and that's going to require surgical removal and possible flushing and other complications. We can use a needle and a syringe, oftentimes more safely than an animal control officer is, to better effect for the, the health care and access of our patients and the public.
I just wanted to add shelters and rodeos.
Yes.
Call for a vote?
Dr. Waterhouse,
Yes.
Dr. Sullivan,
Yes.
Dr. Nunez,
Yes. Yes.
Yes.
Dr. Nolan,
Yes.
Jennifer Laredo,
Yes.
Kathy Bowler,
Yes.
Lee Heller, and Judy Mancuso.
Yes.
Okay, motion passes. We're forging on.
Our next agenda item 7, as you'll recall, we ran into a bit of a sticky wicket with 2027.5, and this was language that was a subset of 2027. And so, for clarity's sake, 2027, the way that it was written, allowed a graduate of one of the schools that's recognized, or that is accredited in section 2022A, a DVM graduate from a school that's accredited as in 2022A, to essentially work as an RVT with the identical job tasks and levels of supervision, yet having never sat for the licensing exam, never been fingerprinted, and some of the other things that are considered to be elements of consumer protection. And so we were tasked with creating 2027.5, which would be a pathway for a DVM graduate from one of these accredited schools in 2022A to be able to function as essentially as an RVT for 1 year after their date of graduation. And that's section B in this. Section A in this is to allow them to sit for the exam, to be eligible to sit for the exam. There's a process they have to go through, but it would create that eligibility. So A is be able to take the RVT exam. B is to function as an RVT with those tasks for 1 year. And then C was an expiration date basically on all of this, and say if you have not been, if you are one of these veterinarians that falls into this category, you've got 1 year to continue your practice, and then you will have to get licensed. One way or the other, your DVM license, your RVT license, you either get licensed or you're not going to be able to function in that capacity.
Comment? Yes, Dr. Nunez?
I agree with the first part. I think it's C was the part that talked about DVMs that are currently performing RVT tasks that have graduated more than a year ago. This language says if you are engaging in illegal activity, you can continue to engage in illegal activity, but you need to stop doing it after a year. So it's basically giving. Is that what it's saying? It says any person who is currently performing the RVT job task without a license shall cease practice after 1 year. Right. So these people shouldn't be performing RVT tasks. I mean, they can, but according to what our regulations say is that you don't have an RVT license and you shouldn't be performing these tasks. I acknowledge the fact that they're qualified to because they do have a DVM degree, but those are people that have graduated more than a year ago, so they could potentially be people that have graduated 20 years ago.
I think maybe this would be a good time to have council weigh in.
Sure. Thank you, Dr. Nunez. Members, if you look at the paragraph right above the red language, heard Epler expressed concern. I'm going to express that concern here again. One of the things that we had talked about yesterday at the NBC was the fact that the people that some of this is aimed at are authorized by regulation to do that. They carry on unabated now, and so we are trying to correct a little bit of this. Respectfully, item C, there's a legal concern of looking backward. That's a retroactivity that I didn't talk about. Consequently, since I did so well on the last one, I was going to respectfully request that this would be one that I believe I would recommend to the board that it be held for a little more analysis. This is fundamentally different, I think, than the one before because there is no really size or scale or scope analysis that has been done. We don't know if this is 20 folks, if this is one person, if this is thousands. We don't really know that. And so there may be a situation where, in light of not knowing how many folks this would impact, we could ask the board could ask the executive officer and her staff to see if there have been any complaints in this vein. Probably a bad medical analogy, I guess. And see what's going on there. I do suggest respectfully that the board may want to consider asking for both a legal and a sort of programmatic analysis for this to be considered at the next board meeting because this is kind of as Ron Burgundy said at Anchorman, I'm kind of a big deal. This is kind of a big deal. This is a change that I think deserves a little bit of analysis, or a lot of analysis, in both legal and programmatic.
But you would agree that what we're trying to address here is the problem of DVMs who have not been able to get their DVM license, so graduate veterinarians that are working as RVTs without a license, without being fingerprinted, without any accountability.
I think the merit, please don't understand, I'm not on the merits of this. I do not want to get involved. I do not want to denigrate or diminish the merits of what this is aimed at. My concern is purely procedural. I just think that there should be some analysis to go along with this because this is certainly it's the case we have essentially a way that a person who is unsuccessful in their attempt to become a doctor, become a licensee, falls into this other category, which they can apparently, given the regulatory structure, carry on unabated, essentially forever. And there are some consumer protection risks or concerns associated with that endeavor because they've never been printed, they've never held a license. There may be some questions about competency. Like I told the board, the MDC yesterday when I was with the medical board, there's a strong correlation between how many times an applicant would fail the licensing examination and the occurrence they would see them in the enforcement realm. So those are the concerns that I think the public policy objective here is certainly warranted. My concern as your attorney, purely procedural.
And they don't have CE requirements like RVT do.
And Dr. Sullivan?
I move that we refer this to staff for further study and report back to us at the next meeting.
Is there a second?
I second that.
Any discussion?
I have one more question. Was it brought up at the MDC about how many people fall under that unregulated, bucket?
That question was asked of both CARVTA and CVMA, and the level of awareness was very small. We think we're talking about a very few number of individuals here. Yeah.
And then a second point, which I guess may be moot, but I just want to bring it up. If a student theoretically took their boards out of vet school and failed, and then went to take it again in 6 months, which I believe is about the appropriate time, and failed again, would there be an opportunity within that 1 year to then take the RVT test, or are they offered at the same time? I just don't know that. So in other words, is the 1 year very constrictive, or is it have adequate time to regroup and go back and take the RVT test?
I don't remember what the testing dates are. I mean, there's a couple of opportunities in that time frame, but they may overlap with the DVM exams.
Any other comment? Any questions from the public or comments from the public? Call for the vote. Yes.
Sorry, Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Dr. Nunez.
Yes.
Dr. Nolan.
Yes.
Jennifer Laredo.
Yes.
Kathy Bowler.
Yes.
Lee Heller. And Judy Mancuso.
Aye.
Okay, we will break for lunch. And we will come back at 1:30.